Research Case Study Presentation, New York Times and Company versus Sullivan, and Gertz versus Robert Welch Incorporated. A presentation by Emily Carson. United States Supreme Court, New York Times and Company versus Sullivan, 1964. Argued January 6, 1964. Decided March 9, 1964. Who are the parties to the case and what facts led to their dispute? The parties in the case are as follows. In the original case, the plaintiff was L.B. Sullivan. Defendants, the New York Times Corporation, and 4 individuals, Pastor Ralph D. Abernathy, Pastor Fred L. Shuttlesworth, Pastor S.S. Say Sr., and Pastor J. E. Lowry. In appeals, the plaintiff was the New York Times Corporation et al. Defendant, Commissioner L.B. Sullivan. The facts that led to their dispute. An ad taken out in the New York Times by the Committee to Defend Martin Luther King and the Struggle for Freedom in the South contains several embellished statements in order to garner support to raise funds to free Dr. Martin Luther King Jr. The ad depicted the police efforts in Montgomery, Alabama against college-aged men and women fighting for equality in the South. Why did Sullivan feel his reputation was damaged by the New York Times publication? The ad that the Committee to Defend Dr. Martin Luther King submitted to the Times contained several embellished accounts of events that took place during the Civil Rights Movement in the South. Mr. Sullivan was the Montgomery City Commissioner who was responsible for police conduct, and, since some of the exaggerations reflected poorly on the police, the ad horribly damaged his reputation as a commissioner. What must the plaintiff show to prove defamation or libel? In order to prove defamation, which is libel or slander, a plaintiff must prove the following. The statement had to have been published. This could mean it was heard by either another party or parties, or that the statement was written and distributed to the public. In this case, the libelous statements were written by the Committee for Dr. Martin Luther King and distributed through the New York Times. The statement had to be false. If the written statement turns out to be true, then it hasn't injured the plaintiff's reputation. It has only revealed information about the plaintiff. The statement was unprivileged. Public officials cannot be sued for defamation if the libelous statement was made while the speaker was serving in an official capacity. So this freedom has also been granted to the press and to the public. Injurious. The statement had to significantly hurt the plaintiff's professional and personal reputations. This could also include any loss of income because of the libelous statements. Public officers must also prove actual malice. The U.S. Supreme Court wanted to ensure the public never lost their right to speak out about the actions of public officials because that is what America was built on. The court decided that public officials had to prove actual malice in order to keep courts, like those in Alabama, from trying to silence media and citizens who speak against the majority. This means that the officials had to prove that the statements were false and that the speaker knew they were false but did not have any regard for the damage the statement may cause. What was the U.S. Supreme Court decision, and why did it make that decision? The U.S. Supreme Court reversed the decisions of the Alabama court rulings and dismissed charges against the New York Times Company and the 4 individual pastors, Ralph D. Abernathy, Fred L. Shuttlesworth, S.S. Say Sr., and J.E. Lowry. The court's decision, delivered by Justice Brennan, stated several reasons for the conclusion. United States Supreme Court, Gertz v. Robert Welch, Incorporated, 1974, argued November 14, 1973, decided June 25, 1974. Who are the parties to the case? Is the petitioner a private person or a public figure? The parties involved in this case are Elmer Gertz, plaintiff, and Robert Welch, Incorporated, defendant. Gertz was a local private lawyer who was asked to serve as part of a prosecuting team against a police officer charged with killing 17-year-old Ronald Nelson. Gertz was singled out as being a communist supporter and the leader of an effort to discredit the local police. He was also reported to have authored an essay criticizing police conduct called Dissent and Disorder. Robert Welch was the owner of American Opinion magazine. The article he ran in the monthly publication was entitled Frame Up, Richard Nucio and the War on Police. What were the alleged defamatory statements about Gertz in the American Opinion article? The article depicted Gertz as a police hater and part of a communist group who wants to undermine the police. He was also stated to have been a former member of the Marxist League of Industrial Democracy and vice president of the Communist National Lawyers Guild. What was done to confirm the accuracy of these allegations against Gertz? The managing editor of American Opinion, Scott Stanley Jr., said that he had no reason to check the validity of the statements made. The freelancer, Alan Stang, had done work for Stanley in previous issues, and he was always truthful and thorough, so Stanley felt no reason to doubt his statements in the article. How do you think these allegations affected Gertz's reputation? Gertz's reputation with the city of Chicago was severely injured. The entire city thought of him as a communist because of that article, so I believe he had to work twice as hard to assure clients of his loyalty to the United States. What would you have done differently than Welch to avoid the lawsuit? If I were Welch, I would have made the decision to pull the article if the information was not proved true. Suits such as this one can end up costing smaller companies enough to shut down, so it is important to fact-check everything that will be distributed with your brand's name on it. What is your state's defamation law? According to the Georgia Defamation Law, the elements of a defamation claim are 1. A false statement about the plaintiff, 2. Communication of the statement to a third party in the absence of special privilege to do so, 3. Fault of the defendant amounting to at least negligence, and 4. Harm to the plaintiff unless the statement amounts to per se defamation. How can you relate what you learned from the Sullivan and Gertz cases to your future work in the communications industry? 1. Always check and double check your sources. 2. Never publish any invalidated material. 3. Be familiar enough with the law to be able to properly apply it when necessary.